solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Before you proceed, this has nothing to do with you or anyone else personally. We as legislators do not operate in a vacuum. And there is a feeling, not just a feeling, there is a knowledge that there are cases where we have been stonewalled and where people don't want their people to testify, and they are cautioned about what they have to say. And we are, one of the reasons we're coming before this committee is because we do swear people in. And I just want to caution everyone, so that get the word out there, that if you come before this committee and there are going to be questions asked and we think that you're going to be anything less than truthful, that we're going to get specific answers. I don't know if the prosecuting attorney will do anything about it or not, but I intend to pursue it because this is the state legislature. We are the representatives. Each one of us represents either about 83,000 to 85,000 people or 27,000 to 30,000 people. When we're asking a question, we're asking for the people of the state of Arkansas. And no one in any agency should think that they're going to get around this. And like I said, that has nothing to do with you. But I think it very definitely needs to be said. So thank you for coming. And I hate to have such a pall before you testify. But please proceed.
Thank you, Senator Clark. We do appreciate the opportunity to be here. I know that Mrs. Little and I have tried to attend as many JPR meetings as we've been able to on the topic of child welfare. We appreciate the legislative body taking such an interest in child welfare issues. It's my passion. I am the director of the Community Neglect portion of Attorney Items. I want to make a clarification. I think there's been confusion by many members of the legislative body and the public with regard to the attorney's item. There are two separate types of attorney's item. There are attorneys who are appointed in domestic relations or probate cases to represent children, and there's not really a formal program for those attorneys. They are required under Administrative Order 15 of the Supreme Court to have additional training before they can take those appointments. And there's an appropriation for them, which is reimbursed through the Administrative Office of the Courts. I don't have any involvement with domestic relations or guardianship attorneys item. So our program, the only formal program for attorneys item, is dependency and neglect attorneys item. We represent the children in any case that's filed before the circuit court where there is an allegation of dependency and neglect, meaning that there's an allegation the child has been subject to abuse or neglect in their home of origin. Sometimes children are removed from the home. There are other types of cases where the children remain in their home, but there's still a circuit court case. Every single child is entitled to an attorney of item to be appointed to them. We represent under statute and under the Administrative Order 15, we represent their best interest. So it's not client directed, meaning that the child doesn't get to direct the type of representation we provide. We are mandated to do an independent investigation of the circumstances. We gather information from the Department of Human Services, but not solely from the Department of Human Services. We talk to therapists, we talk to doctors, we talk to counselors, teachers, neighbors sometimes, law enforcement, the parents or relatives of the child, to try to get a picture of what's happening in that child's world and what we think is in the best interest of the child. We're also mandated to make sure that when we go to court, we advocate as an attorney, we make sure that evidence is presented to the court about the best interest of the child. The court's entitled to all relevant information about the child. So if there's information the attorney of item has that may not support their recommendation to the court, we still have to make sure that the court has heard that information so the court can make the best decision possible. Mary Beth Louisville will talk about CASA, but we also work with the CASA, the Court Appointed Special Advocates. They also advocate for the best interest of the child, but their role is a little bit different, and she'll be able to more fully explain what that is. I'm not sure whether or not you got the handout that we had submitted last July when we were first going to the European agenda. In the handout that's outside, I know that there's a flow chart of the court process.
Excuse me, that is Exhibit F2.
There was also some program information that we provided at that time But the exhibit F2 is in your packet. That kind of goes through the flowchart of the types of cases or the type of hearings we have in a case. Some people are confused that maybe there's one hearing, one trial that determines whether or not there's a defendant's neglect case. But in the circuit court, that case goes on, as we kind of discussed. It may go on for a year. It may go on for 10 years if the child remains in the foster care system. There are multiple levels of reviews of the case. There are permanency planning hearings where we come back to the court at least annually to ask the court to make decisions about what the permanency goal should be for the child. I think there was a question earlier of the average amount of time that cases are open. And I don't have an exact number. Most cases are open somewhere between 12 and 15 months. We are able to achieve reunification, meaning the child is able to go home to their family of origin in the majority of the cases. If they are not, then we look at relative placement, guardianship, some other type of permanent custody for the child, or it may be a termination of parental rights with adoption for the child. So we're seeing there that after permanency planning hearing, there may be a termination hearing. There may be continued reviews for that child after the fact. Children in Arkansas are allowed to stay in the foster care system up to the age of 21. I'm very proud of Arkansas for allowing juveniles to stay in the foster care system until 21. Other states are just now opening those doors for children to access those services. They have an attorney involved throughout the entire case. Some of the numbers, in fiscal year 2015, there were 32 full-time attorney involved. As Mr. Welch advised the committee earlier, we do have a combination. We have some full-time attorneys at Lyman, and we have some part-time contractors. In Arkansas, under Administrative Order 15, we have caseload caps. So a full-time attorney at Lyman has a cap of 75 cases. We do have some attorneys who fluctuate over that amount. We're certainly in a foster care crisis at this moment, and caseloads are growing faster than we can hire contractors to help with that. So we do have many attorneys that are carrying a little over that amount, 80 to 100 cases. For part-time contracts in Arkansas, Administrative Order 15 sets the cap at 25 cases. As Mr. Welch pointed out, we pay $800 per case per year on those cases if you are starting with our program. After you've been with us for 3 full years, if you started your 4th year, we bump that to $850. And if you've been with us for 6 full years, we bump that to $900 per year per case. Our starting salary for our full-time employees is $45,000, which is not a lot of money for a full-time attorney. They are a pay grade 127, I think is the accurate pay grade. And so the cap there is about $80,000 once they've been with that program for a significant period of time. In fiscal year 2015, we have 5,604 cases that involve 8,981 children. So when we talk about case counts for attorneys, we are talking about the entire case. There may be one child in the case. There may be 8 or 9 children in the case. So we want to make sure that you understand that's 8,981 children that we're representing. I'd be happy to take questions from the committee or clarify what our role is.
Attorney at Lyman's represent children?
Yes, sir.
I understand that, but sometimes I want to represent children and primarily, are you primarily involved in maltreatment in those cases, or do they also play a lot of other roles?
We're only appointed in dependency neglect cases, but certainly in the course of a dependency neglect case, these issues are extremely complex. We are dealing with the well-being of the child. We're dealing with educational issues. So we have to be up on their IEPs and making sure that we're getting the special needs they need educationally. We have to know about mental health issues, advocate for appropriate counseling services, medication management. Many of our children have diagnoses where they're on multiple medications. We have to be informed of placement issues. There's a broad array of issues that we deal with, including